Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Ross, Lanier, and Deifik.
Thank you, Morgan, for the introduction. Well, welcome back to the show, Celia.
Thank you.
Tell us a little bit about yourself, okay?
Well, I have been board certified in real property law since 1990. I specialize in real estate litigation. I'm with Ross, Lanier, and Deifik. Deifik is me. And I do just about all kinds of litigation concerning real estate.
Just primarily real estate?
Real estate's business issues too, because often they're interlocking.
Together.
Yes.
Right. And where are you located?
We are downtown on the corner of 6th Avenue North and the Trail in the Capitol Bank building, about 11 blocks north of Four Corners.
Now, the last time you were on the show, a couple months ago, we were talking about different attorneys. And tell us a little bit about your certification of attorney.
Well, the Florida Bar has a number of what we call certification areas. And in order to become certified in one of these areas, you have to undergo rigorous testing. Also, the bar checks with everyone in the community that you work with. And so if you can pass exams and demonstrate this specialized knowledge, then you earn the title of board certified, whether it's in appellate law,
whatever.
Real estate, probate and estate planning, those types of things. Now, the other thing that the Florida Bar does is it's not enough that you merely pass the exams. You have to recertify every 5 years. You have to seek recertification every 5 years, and the bar does a new inquiry in the community, and you have to show that you have done so much continuing legal education in your field and demonstrate your knowledge of the topic.
And the percentage-wise of attorneys have that distinction?
Well, actually, and I'm sorry I don't have the exact statistics, but it's a very small percentage.
That's what I thought.
For instance, I think in real property, only about less than 5% or 4% of the members of the Florida Bar are board certified. In some other certification areas, it's even less. Now, some people may not feel that the certification is worth their time because it does require a lot of demanding, as I said, extra time,
right,
legal education and expense and things like that. But the bar does it, and many bar associations around the country do it because it does give the consumer some knowledge as to whether the person is really well versed in their particular area and whether they are well regarded by their peers.
Okay. Well, we're here today to talk about something that I feel there's a lot of cases like this in our field, selling real estate or people buying real estate or listing their properties, is open permits. So
big problem.
And people, the consumer, people move down here or have work done in their homes, really don't realize really what the procedure is. They hire a contractor, they do the work, they pay it, and then when we sell the house or somebody's purchasing the house, they have an open permit. So maybe you want to discuss in our first segment here, what is an open permit?
Well, an open permit occurs when, just as you said, the homeowner has had work done, and to the homeowner, the work appears to be complete, and they pay the contractor in full, and the contractor goes off into the sunset. Years later, they will find that indeed the work was not completely finished, and more importantly, the contractor did not have the building department come out and do the final inspection. And until that final inspection is done, that permit cannot be closed. And this creates a huge issue. And I have seen it tank real estate deals. One of the types of work I do is litigation about real estate contracts, purchase and sale agreements, people fighting over these things. And this can either cause a buyer to want to not purchase the property or want to renegotiate the price. One of the reasons it is such a problem is that often by that point, the original contractor is no longer in business and nowhere to be found. So you can't have him come and get the permit closed out. You must have a licensed contractor do it. You call a new contractor and he's generally concerned or unwilling about coming into a problem because he does not want to be assuming the responsibility. So one of the things I was telling you, Jim, is one of the Florida Bar real estate section committees has worked on some proposed litigation to solve this problem. Now, it's only in the works, and it wouldn't even be presented in the legislature until the 2017 session, if then. But the purpose is to create an efficient and economical procedure so that the homeowner or the purchaser can get the permit closed. And one of the several ways that the bill would do this is by eliminating the problem that we just touched on. And the new bill would say, when the new contractor comes in to get the final work done and call for a final inspection, he will only have limited liability. He is not assuming responsibility for all of the other problems. Now, certainly if there's a life safety issue, he needs to bring it to everyone's attention. The other things that the bill would do is only require that the work be done to satisfy the code as it existed at the time the original permit was issued. And that can make a huge difference in money, time, and expense. Also, the bill is going to make failure to close an expired, open, unclosed permit, I've heard them called a number of different things, a grounds for discipline against a contractor, assuming he still is in business.
So basically you're telling me that in the existing real estate contracts today, in our local board or the state, there's no provisions in that contract to address this problem.
There's no provisions for allocating that problem. Now, I will tell you the FAR Bar contract does not mention it, and it certainly does not require the seller to undertake that expense. So what generally happens is there's arguments about it. Now, I've seen it come up under the NABOR contract, but this, if this bill passes, it will give, as I said, an efficient mechanism for resolving this.
Well, we're going to take a little short break, and we're going to come back and talk about if you can't solve this problem, what do we do legally, okay?
Okay.
We'll be right back.
All
Thank
right.
you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Well, I think we covered a lot in our first segment here, and now, okay, you can't resolve this. What's the next steps? Do you, we're under contract, let's just put it this way, we're under contract, we find out from either the title company or the home inspector, that's what we should mention, that's how these things pop up. And nobody
Wants to take responsibility?
That's right, so what do we do then?
Well, first of all, is going to depend on what kind of a contract we have. If it's an as-is
Right.
contract,
Right.
the buyer may have the right to walk.
Mhm.
And if the seller wants to preserve the deal, the seller is going to scramble to try and fix this problem.
Exactly.
But then the seller runs into the wall that we were talking about earlier. In other types of contracts, often it either results in some negotiation because everyone wants to save the deal, or the deal blows up and then people are suing each other over whether or not each party performed their duties. Now, an unclosed permit, or an open permit, as you call it, is not a title defect.
It's not a title
It
defect.
is not a title defect, no.
I didn't know that.
So if the buyer is trying to say, well, Mr. Seller, you must fix it or you're not going to be giving me good and marketable title, I don't think that argument is going to fly.
Well, how's that, do you know how that affects a mortgage company with having an open permit?
Well, it certainly depends on who the lender is. If it's an FHA or VA, they're going to demand that everything is taken care of.
Right.
Other lenders may not care particularly, especially if it's a small item. The buyer, if the buyer chooses to go forward with the transaction, they are going to need to get it done.
That's right.
Now, currently, and this varies from county to county and building department to building department, sometimes building departments will refuse to let you pull a new permit for some other type of work if you don't take care of
that
this one.
Right.
So the other thing that this provision or this bill, assuming that it ever makes it into law, which I'm very hopeful it will, it tries to give some aid to the closing agents also by providing that only one search fee should be charged even if there are multiple issues that you're searching in a municipality. And also, there are some alternate procedures in the bill, too involved to go into here, to give a homeowner or purchaser a method of getting this permit closed without spending a lot of money. Another thing that will happen is if this bill passes, it imposes a responsibility on government building departments to send notices to homeowners because, as you mentioned,
That's right.
they're often not aware
They're not
that
aware.
there's still an open permit. Now, there are some counties around the state that do that, but not all of them do. So this would mean that whoever is living in a home is going to get a regular notice saying, you need to do something about this.
What, does this affect title insurance, getting title insurance, having an open permit?
No, I don't believe it
You don't
will.
believe it?
I don't see it as a title defect.
So I've run across, not myself, but I've heard of some cases that the home inspector or the title company, whoever did the search, didn't pick up the open permit, and somebody, enclosed their basement down here, it was built on stilts and enclosed it. And then they went to sell the house and couldn't sell it because of, it wasn't built to code.
Right,
So in that case, kind of what happens?
Well,
mean-
that often is an issue to take up with the closing agent's O&E carrier, errors and omissions. What you're talking about is a far more serious issue than
That's right.
merely an open permit. And we do see it a lot in Florida, especially with elevated properties in flood zones,
Right.
where people enclose the lower level. Now, that would cause a mortgage lender to want to withdraw their loan if that was not fixed. Now, Collier County has a good program where for $250 you can have code inspector come out, not laying blame on anyone,
Just-
to look at a home and tell you if it is indeed up to code.
Okay, they will.
And that, gives you some peace of mind so that you know what needs to be done.
So a lot of people, they enclose their garage and stuff like that, so they could have somebody come out for $250 and inspect the place.
Yes.
Does that open up a can of worms or not? Or
Well, if you're buying a property and you're making one of the biggest investments in your lifetime, that's the kind of thing you want to know. Now, certainly sellers who have done this are not likely to want to bring it to light. But sometimes the seller themselves is not aware that this has happened because they never checked when they purchased from the prior owner. Now, you can get retroactive permitting, pay a penalty, and some things will be permitted. I don't think that type of code violation is going to be permitted. I think the county's going to make you take down the walls.
Okay.
But it depends, clearly.
Maybe you can't answer these questions, but how about if there is an open permit and the code changes? Would the permit, when they redo it, would it have to meet the current code? Or
that has definitely been a major concern of a lot of people. And this proposed legislation specifically would provide that if and when you hire a contractor to get an inspection, finish the work, close out the permit, it only has to be brought up to the level of the prior code, not the current code.
Okay.
And the other thing it's going to provide is that building departments would not be able to deny you other permits as long as you're taking care of it within a specified period.
Right. So before we wind this show up here on this subject, I'd like to tell our viewers how they can avoid having this problem by hiring a contractor and maybe making sure that they have the final CO or final permit.
Well, certainly, and as I mentioned to you, I saw this happen to my own mother. You hire a contractor, it's not enough for him to show you the pretty patio or whatever he's built. You need to call the county, check on permits, and make sure all final inspections have been done and all permits have been closed.
Okay. And they'll give you a form that says this. Well, thank you for coming on the show. And I'll tell you, this was, I think, will help our viewers tremendously, the consumer, even though they're real estate agents. So I look forward to you coming back on. Well,
thank you. As I told you, I just got back from a conference of real property committees, and this was a major topic of discussion.
It's something that needs to be addressed. Thank you, and we'll see you next week.